The phone rings at 2:47 a.m. You are awake. You are always awake when it rings at this hour, not because you anticipated this call, because you have learned over 5 years that the calls worth taking do not arrive at convenient times, and the ones that do are rarely worth taking. You look at the number, not saved. You pick up on the second ring, not because you are eager, because hesitation is information, and the person calling at 2:47 from a number they have never called from before already knows more about you than you know about them. And the 2 seconds you spend deciding whether to answer is 2 seconds of data you have handed them for free. You say nothing. They speak first. A name, a situation, 4 sentences. The kind of 4 sentences that contain everything and explain nothing, and are designed specifically to communicate urgency without committing to details on a line neither of you controls. You say, "I'll call you back in 8 minutes from a different number." You hang up. You sit on the edge of the bed in the dark for 30 seconds, not thinking about the call, thinking about what the call means. Before you know what the call is, the number was not saved. That means the person calling has been careful about how they contact you, which means they have thought about this before dialing, which means the situation is not new. It has been developing, and the moment they decided to call you at 2:47 a.m. is the moment something in the development changed. Something accelerated or something arrived that was not supposed to arrive yet. You pick up the second phone. You call back. You do not have a business card. This is not an oversight. Your LAC is registered in Delaware. Generic name, 2 initials and the word advisory. A website with 4 sentences that describe nothing specifically and everything accurately. Incorporated by a registered agent who has never met you in person and would not recognize you if they did. You do not invoice clients directly. Your invoices route through a law firm, 40 partners, 3 cities, 2 Fortune 100 relationships that provide institutional legitimacy, the way a foundation provides structural integrity, not visible from the outside, essential to everything above it. The firm engages you as a crisis communications consultant. They invoice you to the client as part of legal services. Every communication between you and the client, routed through that firm, is protected by attorney-client privilege. Not because you are an attorney, because you are an agent of attorneys engaged in legal work, and the privilege attaches to the engagement. You have paid $1.4 million in federal income tax in the last 3 years. Legitimacy is not a cover story. It is the entire architecture. Without it, you are a criminal. With it, you are an advisor. The work is the same. The structure is everything. The man on the phone is 53 years old. You know this before he tells you. You know the name of his general counsel, the law firm they retain for securities work, the name of the partner at that firm, who handles matters that do not appear in engagement letters, and the approximate date. 3 weeks ago, when something changed in the pattern of communications between that partner and a specific investigative journalist who covers financial regulation for a publication whose editorial standards you have reviewed in detail. You know all of this because knowing it is the job, not the reaction, the preparation. He tells you the situation in 11 minutes. You listen without writing anything down. Not because you will remember it, because a notepad in this conversation is a document. And documents have locations, and locations can be subpoenaed, and the 11 minutes of information he is giving you right now should not exist anywhere except inside a structure that makes it inaccessible to people who have not been invited into it. When he finishes, you ask 3 questions, not the questions he expects. Not about the situations itself, about the perimeter of the situation. Who else knows? In what form they know it? Whether the knowing happened inside a privileged structure or outside one. His answers tell you more than his 11 minutes did. The situation is manageable. The perimeter is not. By 6 a.m. You have made 4 calls, not to him. Not to his general counsel. Not to anyone whose name would appear in a record of calls made in connection with this matter. The first call is to a law firm in Washington whose founding partner spent 11 years as Associate Director of Enforcement at the relevant agency before leaving. To build a practice that bills at rates that look impossible until you understand what they are actually selling. They are not selling legal skill. They are selling institutional knowledge that required a decade of government service to build and is not available at any price to anyone who built it differently. The revolving door is not a scandal. It is a feature. Government builds knowledge. Private practice monetizes it. The system designed this pathway. The system continues to permit it. Understanding this is not cynicism. It is accuracy. The second call is to a contact at a media company that owns, among other properties, the publication whose journalist has been in communication with a source connected to this situation. The conversation takes 4 minutes. Nothing is agreed to on that call. Nothing needs to be. The third call is to a forensic accounting firm that does not advertise and is known only through referral within a specific network of people who have needed what it provides. The fourth call is to a number I do not call, often former intelligence service, not American, a service from a country whose intelligence culture is older and less constrained, and whose principles, when they enter private practice, bring with them a set of capabilities that private practice in this country cannot replicate through any other pathway. Their fee is significant. I approve the engagement before the call ends. I do not sleep well that night. Not from guilt, from the specific discomfort of knowing what 2 weeks of that engagement produces and having already decided what I will do with what it produces. The source is a woman named Teresa, 41 years old, former employee. A civil judgment from 2 years ago she has not satisfied. An attorney she retained 6 months ago whose own financial situation, a recent practice dissolution, and a custody arrangement with terms she cannot renegotiate, makes him more interested in a settlement than in a fight. She has spoken to the journalist twice. The second conversation went further than the first. What she shared in the second conversation has not yet reached the editor. That gap between what has been shared and what has been transmitted is the only window that matters right now. I read the full intelligence document in 22 minutes. 41 pages. I read it once. I do not read it again. I request a meeting, neutral location, a hotel lobby in a city that is not connected to either party. Morning. Public enough that the context is unremarkable. Private enough that the conversation will not be overheard. She arrives 7 minutes early. She has a yellow legal pad with notes on it. I recognize the notes immediately. They are things her attorney told her. Arguments, talking points, the version of the situation he built for her, based on what he knows. I know more than her attorney does. I sit down across from her. I do not introduce myself by name. I order coffee. I tell her I am going to describe her situation to her accurately and completely, and that when I am finished, she should take whatever time she needs before responding. She nods. She is holding the legal pad in a way that tells me she was planning to use it and is now uncertain whether she will. I begin, not with the situation as she understands it, with the situation as it actually is, what her existing agreement permits her to do and what it prohibits. Not the version her attorney summarized. The actual text, specific clauses, the case law that applies to each one in the jurisdiction where the agreement was signed, what litigation would look like from her side, the timeline, the cost, the opposing counsel she would face if this proceeded, and their motion history in matters of this type, their average time to resolution, the percentage of similar matters that reach trial versus settle, and at what stage the settlements typically occur, what she currently holds and what she believes she holds. Those are two different things. I explain the difference precisely. I make no threats. I offer nothing. I simply ensure that when she stands up from this table, she has a complete and accurate picture of her actual situation. Not the situation her attorney described, not the situation she imagined, the actual one. Complete information without pressure produces its own outcome. She is not coerced. She is informed. The distinction is real. Legally, it is absolute. I have not finished that sentence in the way I used to finish it. I know where the rest of it is. I do not open the file. Her attorney calls my attorney 6 days later, a revised settlement. She signs. The media situation moves differently. The journalist has a source, had a source, and is now operating without one, without a source. The story exists as a collection of unattributable information that no publication with functional legal review will run in its current form. The journalist does not stop. Journalists who stop when a source goes quiet are not the ones who build careers covering this category of story. She makes 11 additional calls over the following 3 weeks. I know about each one within 48 hours, not because I surveil journalists. Because when you have spent 5 years building a network inside the specific industry a journalist is reporting on, the information moves toward you, the same way water moves toward the lowest point. You do not have to seek it. You simply have to be in the right position when it arrives. On the 14th day, a media company approaches her with an offer. Not for the story she is reporting, for a profile of a different subject, a figure in the same industry, unrelated to the current matter, but significant enough to represent a meaningful career opportunity. The offer is real. The profile will run. The timing is a coincidence. The way most timing in this work is a coincidence. She accepts. She does not drop the original story. Journalists with her level of commitment do not drop stories because another assignment arrives. But the original story moves to a secondary track. Secondary tracks have resource constraints. Resource constraints have timelines. And in 3 months, the publication's editorial calendar will have moved on to matters that are newer and more pressable, and do not require a source who is no longer speaking. This is not a guarantee. It is a probability. At this level, managed probability is the product. The regulatory matter is handled differently. A subpoena for financial records from a transaction 4 years old, narrow mandate, defined scope, a budget cycle ending in 7 months. The law firm in Washington begins document review on a Tuesday. Attorney-client privilege is asserted broadly. The privilege log is 340 pages. The SEC does not challenge it. Challenging it would require resources and time that the budget cycle does not accommodate. The investigation closes in month 6. Insufficient evidence for enforcement action. Total cost to the client, $11.2 million. $11.2 million is the price of a specific outcome. Defendants without $11.2 million receive a different one. The legal system is not corrupt. It is expensive. Those two things produce the same result often enough that from the outside, they are indistinguishable. There is a file I returned. It arrived through a channel I recognized. I opened it. 3rd paragraph. I closed it. not after deliberating. The decision was made in the third paragraph. The 17 minutes that followed were something else entirely, the process of making a refusal permanent. The kind that will not be renegotiated regardless of what number arrives with the next call. I called back. 2 words. The voice on the other end said someone else will handle it. The response was immediate. No pause. No surprise. That immediacy, the fact that an alternative existed, already named, already ready, is something I sat with for a long time after the call ended. I know what someone else means in this network. I have redirected work to adjacent firms before, without knowing the full content of what I redirected. I told myself the distinction mattered. Sitting in that room, I understood exactly how well that argument holds, and exactly where it doesn't. The line I kept is the only one I kept intact. The others moved over 5 years, one recalibration at a time. Each one had a reason. Each reason was defensible in the moment it was made. That is not a confession. It is a description, accurate. Here is what 5 years of being the sequence does to the person running it wide. You read people differently. Not as people, as documents. You meet someone. And before a full sentence is finished, you are already mapping. What do they hold? What do they want? What are they not saying? What would it take to produce a different decision? This is useful in the work. It is not useful anywhere else. You stopped going to dinner parties sometime in year 3. Not a decision, a gradual unavailability. People ask what you do. You say consulting, they ask for who. You say you can't discuss clients. They assume corporate and move on. There is nobody in your life who knows what you actually do. Not a partner, not a close friend. Nobody. This is not loneliness. It is something more specific. It is the condition of having a context that cannot be exported. You are not a different person. You are a person whose work cannot be described in any room that is not the room where the work happens. You had a close friend law school. 15 years. Dinner twice a year for a decade, reliably, the kind of reliability that requires no planning because it has become structural. You have not called him in 14 months. Nothing happened. No break. No argument. No moment you can point to. You simply reached a point where you were sitting across from him at dinner and could not contribute a single honest sentence about your actual life. And the performance of ordinary conversation started to feel like its own kind of work. You told yourself you would call when things slowed down. Things have not slowed down. Some nights you look at your phone and think about the 14 calls logged in the past week and realize there is not one person in the contacts you can have an honest conversation with about any of them. You file that away. The filing system is very organized. You have never run out of space. In year 1, you would have called this compartmentalization, a professional skill, the ability to separate work from self. You are less certain about the vocabulary. Now, compartmentalization implies a wall. What you have is more like a slope, gradual in one direction, and long enough that the starting point is no longer visible from where you are standing. That is either a professional asset or a description of a problem. You have not decided which. Deciding would require opening the file. Every story you read about a powerful person, stop asking whether it is true. The true parts reach you. Ask what existed before this became the story. What was handled before the journalist made the first call, before the investigator opened the first file, before the question was even possible to ask. That question has no answer in any publication. The answer was handled before the publication existed as a possibility. That is not a conspiracy. A conspiracy requires a plan that can be described. This has no plan, it has a result, and a result achieved through the precise and expensive application of every legal tool the system makes available to people who can afford to use all of them simultaneously, looks identical from the outside to an outcome that simply never happened. The philanthropy is real. The hospitals are real. The scholarships are real. The business that built what they have is real. Beneath all of it, not contradicting it, running beneath it the way groundwater runs, beneath the structure you built on top of it without knowing it was there, is a layer of resolved situations, not erased, resolved through time, through structure, through the specific application of tools that have always existed and have always been available and have simply never been accessible at this price to anyone who could not afford to use all of them at once. It is 4:19 a.m. The first call is handled. I set the phone down on the table. Outside, the city is doing what cities do at this hour, running on a skeleton of itself, the version that operates while the version people know is asleep. I have been the skeleton version of things for 5 years. I am very good at it. Somewhere right now, another phone is ringing, a number that is not saved. Someone who has been sitting with a situation for weeks, maybe months, and has reached the moment where sitting with it is no longer a viable option. They are dialing a number they have been given by someone who has been given it, by someone who was told only that when something exists that cannot be discussed with anyone else. This is the number. It rings twice. Someone picks up, not because they are eager, because hesitation is information, and information at this level is the only currency that does not depreciate, the only asset that cannot be seized, the only thing in this work that is truly permanently yours.